Yes. Hmm.
May I please, Your Lordship?
Yes.
I'd like to mention item number 3,
Hmm.
order. The leading counsel, Nalopada sir, is out of station, some illness. So he requests me to take the adjournment today and also took the consent from the other party also. Serial number 3,
Okay. Mention is made on behalf of Mr.
Nalopada
N.
sir.
Pada,
N. Pada, madam.
leading counsel for the petitioner for adjournment of the matter with the consent of the respondents. Accordingly, list after 2 weeks.
Okay. Much obliged, ma'am.
My appeals, my lord.
Yes. Oh.
My lord, this is the PL pertaining to the one building which has been erected in front of the government office. Here in this case, my lord, before come to the record,
Hmm.
how the building has been erected. The building has been erected in front of the public district library.
Hmm.
The place was allotted for the district library. State, or my lord, this should be state library, which is appear in page number, my lord, 16. In due course of time, my lord, the
Yes.
respondent number 5 and 6, 5 and 6 are there spouse. 6 is none other than the sitting MP of the Eastern Parliament.
Hmm.
They have erected the building, and by the photo, my lord will find that this erection, my lord, erection of the building has, this construction of the building is beyond the, my lord, illegal. So far in the state of Arunachal Pradesh, my lord, the illegal encroachment has been done in everywhere. But till today, at least to the front of the government office has not been occupied by any other person. But this is the first building. Whoever, this is the private respondents are the first person whoever occupied the front of the district library and thereby erected this building.
Hmm.
Therefore, I have limited prayer in the form of PL that this building need to be evicted.
Evicted, huh?
So, in due course of the time, my lord, I have received the affidavit in opposition, whereby the affidavit in opposition showing that they have been allotted by the department, by the concerned department, that is the land management.
Yes.
Therefore, this land management was also later on implemented as a party, and that responsible person is the deputy commissioner, and the deputy commissioner saying that he has no idea about why this has been allotted. Therefore, only the concerned person, concerned authority to ensure why this has been allotted illegally, doubly, because it was already
Yes,
allotted
yes.
to this department, and this is to be ensured by the land management, Department of the Land Management. So, therefore, in the subsequent proceeding, it may say that in the last occasion also they have raised that this has been already allotted. But the time when I filed this PL, that through that RTI also, I could not get even when they have been allotted or not. Therefore, at this stage, I have limited prayer that even if this area has been allotted by the concerned department to the private respondent, this is also purely illegal. Therefore, this building need to be demolished. Therefore, the responsible order should be given, endorsed to the state officer. However, my lord, I am to inform, I am honestly to inform this honorable court. The first prayer, I have skipped my first prayer, wherein I have prayer that the direction for chief vigilant, this I have skipped. I am confined with the second prayer only, directing to the chief state officer to carry out the eviction of the illegal structure will over the land of the district library and the information center. So I am confined with this second.
Okay. Second prayer only,
Second-
but
second prayer.
if you
I
check the
skip.
notings, you were supposed to file an affidavit, additional affidavit,
My lord,
isn't it? Concerning what? Additional affidavit will be concerning your new discovery that they were actually allotted.
my lord,
The deputy commissioner or the land, whoever, he's been allotted, the respondent has been allotted this thing, isn't it? A pass.
my lord.
So you have to file an additional affidavit concerning that.
Okay, my lord. Insure.
So many adjournments for you to file an additional affidavit concerning that, the response made by the respondents, private respondents most probably, that they have also been allotted that land. Now you have to respond to that and you have prayed that you may be allowed to file an additional affidavit.
My lord.
Please do that.
Okay, my lord. Because since my lord, this has been handled by the many council, therefore, my lord, I am not concerned with that. Any of my,
So
I am
you
ready.
have to file an additional affidavit in reply to the response made by the private respondents that there have been issued a land pass
Right.
over where they have built the building,
Right.
isn't it?
So,
I heard Mr.
Shimudi.
Shimuti, learned counsel for the petitioner, who submits that he may be granted further time for filing the additional affidavit.
And
Anyone for the respondent? Miss?
For 1, 2, 3 and
Yes, your good name. I'm coming after a long time, so. Miss
1, 2, 3 and 4.
Your name.
G.
Your name.
Ethel, MSG.
MSCA, learned counsel for respondents number
1 to 4.
1 to 4,
Yes.
along with Mr. Yes, please.
Peter.
5 and 6. Peter.
Peter with. Peter 4.
Yes.
Okay, learned counsel for respondent 5 and 6 are present. List the matter after 2
Three.
weeks,
3 weeks.
after 3 weeks.
All right.
Yes.
May I please, my lord? My lord, before my senior argues, my lord, by the last order, my lord,
Yes.
we were directed to file, my lord, affidavit, my lord, by this honorable court, my lord. As the,
Where is it?
my lord,
Additional, affidavit in opposition,
Yes.
not ready.
not ready, my lord. You-
So we'll give them some more time.
Can be fixed on 38th of this month. And
Okay.
also, my
My lord.
letter has already been admitted.
Mhm.
So it will be,
Because
have
the-
to be listed in the hearing column. If not inconvenient to the court, my lord, can it be on 30th?
Already admitted.
Yes, yes,
Yes, in last order it was admitted,
lodge.
but even if it's admitted, it's been listed under what?
Admission.
It's now
So
admission.
we'll make it, it should be listed under orders, isn't
On the
it?
orders.
No,
Yes.
it's listed under admission. It ought to come for hearing.
No, not yet. Let all the, this
Right.
thing, let all the, what affidavits, everything be ready and then only, okay, for admission hearing later.
Pleadings are not complete.
Yes,
Not
so it's not, it's already been admitted.
Admitted.
So, anyway,
My
Mr.
lord, my lord, I'm
DJ.
sorry, my lord. My lord, because I am representing the, my lord, respondents, my lord, they are the officers, my lord, engaged in electoral process, my lord. So, my lord, a little bit more time may be given, my lord, on 8th, can it be fixed on 8th, my lord? 8th of May, my lord.
8th of May. Is
So
it
in
okay?
that case, the matter may be fixed on 15th. For
15th of what?
15th of May for
Oh.
hearing. And in the meantime, by 8th, he'll file the response if he desires, and we'll also join in the meantime. So that matter can be heard. It's a promotion matter. In fact, correction of the.
There's urgency in the
Injustice.
matter, what? Will be filed, be able to be filed by 8. Okay, I heard Mr. BJ Ghosh.
Shaikh.
Okay, BJ Shaikia. Mr. Shaikia.
Lodge.
PJ Shaikia.
Lodge.
Learned counsel for the appellants. Senior counsel. Okay,
Assisted by
learned,
Taba.
okay, senior counsel, assisted by Mr. D. Tapa. Learned, along with Mr.
I am for RCK, my lord. For the private respondent.
Along with Mr.
No.
You're
I am
good.
for the private respondent.
Yes, your good name.
RCK, my lord.
Okay, along with Mr. R. Saikia, learned counsel for respondents number
3, 4, my lord.
3,
3, 4,
3
and 5.
and
Three.
5. 3, 4, and 5. And Miss,
I'm for 1 and 2.
Miss
P. Pangu, Your Lordship.
P. Pagwe, you're the government advocate?
Yes, Your Lordship, for respondent number 1 and 2.
Yes, learned government advocate for respondents number 1 and 2. The learned counsels for the respondent number 3, 4, and 5. I prayed for time for filing of the affidavit in opposition.
Hold on.
Mr. While the learned counsel for the appellant submits that there is urgency in this matter and that the matter may be fixed for hearing on
On 15th.
15th May 2023. Meanwhile, Mr.
R. Saikia.
R. Saikia, learned counsel for the respondents, is to file the affidavit in opposition by
8.
May so and so. And copies of the affidavit in opposition is to be duly furnished to the learned counsels for the appellants. As prayed for, thereafter, this matter may be listed for hearing on 15 May 2023. Yes.
As per the record, Lordship, it appears that Elsa has received registry.
What, this is POXO matter?
This is a POXO matter, Lordship.
Yes, so respondent number 2, notice has been issued. I think we have to see to that first.
Yes, Lordship.
Hmm.
23rd of this law.
NCR is received. Now, service report received from OC. So anyone representing respondent number 2?
Not representing, then Lordship, Honorable Court can appoint amicus curiae or legal aid counsel.
Already
Correspondent.
appointed? Not yet.
I think it's not yet because in court the name is not reflected
Okay,
yet.
so we'll make an order for some legal aid counsel to be appointed. Okay, and who is appearing for the appellant?
P. Tapak, I think, but his letter of absence is there, Lordship.
None apparent for the appellant, while Miss T. Jenny, learned additional PP for the state respondent is present. It is seen that the respondent number 2 is not represented till date, though notice is deemed to be served upon respondent number 2. Via office order dated 13/03/2024. In view of the above, this court find it fit to appoint. Let the registry appoint. Fit that the registry should appoint a legal aid counsel to represent respondent number 2 and list the matter after
3 weeks, Lordship.
3 weeks.
Lordship. Obliged, Lordship.
May I, Lordship, Lordship, here we were supposed to file implement application, Lordship.
Yes, what happened?
So again, the new incumbent has been transferred, Lordship. So I need more time, Lordship.
Okay. You're Mr. Arsakir?
B type of, yeah.
Okay. Heard Mr. Oh, yes, your good name?
B type of, yeah.
B type of
Bomchi type of.
learned counsel for the petitioner,
Yes,
who prays that he may be given further time to file his impleadment application. In view of the above, list after 3 weeks.
Lordship. Obliged, Lordship.
Yes. You're ready for hearing?
Yes, Your
Oh,
Lordship, I'm sorry, Lordship. Today I'm not ready, Lordship, because
Why?
paper book, Lordship, I have not got, Lordship.
how come?
Lordship, and Lordship, last occasion, Lordship, they have filed application number for the appearance.
for that.
Respond for item number 6.
I think that's it here.
Top of function.
Yeah.
Oh, you have got a paper book.
Yes, yes.
Lordship, I have no paper book yet, Lordship. So paper book maybe
Now,
for
again, this is a POXO matter.
Lordship. And victim party maybe,
Oh,
Lordship.
so who's for respondent number 2? Let's see, huh?
Again,
Office
Lordship,
note
there's
indicates
no-
that LCRs have been received. Now here it says that steps for service of notice upon victim number 2 not yet taken.
Lordship.
Then you'll have to take steps. Isn't it? This is 03/08/2023. Steps not taken yet.
You are for the appellant.
Appellant
Yes,
has to
yes,
take a step,
yes.
Lordship.
You have not taken steps on the victim. Steps are taken.
Where?
This note indicates that you have not taken. Because before me is your lordship, some other councils were there. And I filed a case for
You
them.
take fresh steps, right?
Oh. You see, now the victim has to be represented. Yes, Deepak Nair's case. And the Guwahati High Court, the principal seat also had issued a
Mr.
notification.
Jagdish Singh assists me, sir.
So that it has to be
Yes, sir.
followed, isn't it? So we cannot have the hearing today. Mr.
MK Sarma.
M.K. Sharma,
Yes.
learned counsel for the appellant, along with Ms. So-and-so, learned additional
El Hage. Yes, sir.
are present. On perusal of the office note, it is seen that notice upon the victim / guardian for the victim, complainant, informant is not complete. Therefore, the counsel for the appellants is to take necessary steps for issuance of notice to the respondent number 2 by furnishing a copy. No, I think the registry will have to take steps.
Yes.
Okay. With the registry, by issuing notice to the respondent number 2 and the additional PP will issue the notice, will ensure that the jurisdictional police of station of which place?
Long.
Longding, Lordship. Longding.
Long.
Longding serves notice to the respondent number 2.
Lordship, here the appellants should take step, Lordship, upon respondent number.
No, it is usually the APP, who the additional people through the registry. The copy will be served,
Lordship.
copy of your appeal, etc. But then it will be the registry,
Lordship.
okay, who will issue the notice, and I think a format has been
Yes.
made
Yes.
also.
Yes,
Okay.
Lordship.
through the proper format. And the additional PP will ensure that notice is duly served through the jurisdictional police, OC, police, whatever, that place. Okay. And the OC, upon serving notice to respondent number 2, will duly inform the additional PP of the service of notice to respondent number 2. List after 3 weeks.
Lordship. About Lordship.
Waiter, and then after that, we'll say this matter is also released from hearing list. Okay. Yes,
Madam, we appear for the respondents, madam.
who is for the appellate?
One Dr. Kothari. She's an now station council.
Case called up, none appeared for the appellants. While Mr.
D. Pangan.
D.
For the
Tapang,
private-
yes.
Lordship, I'm applying for the PC Lordship for appellant.
You have applied for what?
PC
You
Lordship.
don't have to make an application
I
automatically.
already submit application Lordship.
You don't have to submit an application also now. Okay, there's an order of the, there's a order that if you're going to apply through VC, you automatically this thing appear. So it appears that they have not appeared today. Isn't it?
Online,
It's no longer required. What happens is now you just look at the cost list. Okay, and if an outstation council finds that his name is there reflected, then he automatically appears. Link is given. Okay, in the link is already there in the cost list.
In
So,
any case, madam, this will be definitive, a very voluminous matter. We have connectivity issues we have seen.
so anyway, we'll fix
Yes.
another date. Okay. The leading counsel for the appellant is absent, while Mr. D. Panke, learned counsel for the respondent, is present. In view of the above, list after, when you wanted, 3 weeks?
Why not? I have no issues, madam. Dr. Kothari is from.
List after 3 weeks.
Oh, madam.
Your ladyship, which item is called out?
May I please, your lordship? Lordship, here, Union of India is the appellant. And the against the order passed by the single bench, So, this is on the several occasions, admittedly matter came up for hearing. So, all the way, we came from our home districts, we could not able to prepare the matter. So, at this stage, may I friend, some other date may be given for disposal of the matter, Since today is also for the the hearing, supplementary hearing. 9 is
Yes.
in 11th, 8 will cover, Once the matter is.
Yes.
My lord, this matter, my lord, with due apology, my lord,
Yes,
the appellant has sought more than 11 times adjournment matter in this matter, my lord. It is a compensation matter, my lord. Initially, my lord, after passing of the award, my lord, they have not complied, the ITBP, Union of India, has not complied with the award, my lord, and delayed the payment, my lord, compensation payment. So we approached this honorable court, my lord. This honorable court directed, my lord, the authorities, my lord, to pay the compensation within an outer limit of 3 months, my lord. Thereafter, they did not pay any, my lord, compensation to us, despite the order of the single judge, my lord. Therefore, we filed a contempt application before this honorable court for non-compliance of the, my lord, order passed in a single bench, my lord. My lord, when we file a contempt petition, my lord, thereafter, my lord, they filed a, my lord, appeal, writ appeal against those, my lord, judgment of the learned single judge, my lord, after a delay of 2 years, my lord. That writ appeals were dismissed, my lord. Then in the writ appeal, they sought at liberty to file a LA appeal before the learned single judge. Then again, they filed an LA appeal before this honorable court in single bench, my lord, under section 74 of the, my lord, Right to
Yes,
Fair Act, my
yes.
lord. That was also dismissed, my lord. And my lord, thereafter, after dismissal of the writ appeals and the LA appeals, my lord, they file a fresh writ petition, my lord, the Union of India, my lord, challenging the award, notification and the award, my lord. That has already attained finality, my lord, by the order of the earlier decision of the learned single judge, my lord. My lord, pendency of that, my lord, fresh two writ petitions, my lord. My lord, there is a contempt proceeding going on before this honorable court, my lord, in for the earlier non-compliance
Yes,
of the
yes.
earlier order of the honorable court, my lord. My lord, there, my lord, they have, my lord, assured, my lord, this in the contempt application petition that, my lord, they will pay the compensation, my lord. Despite that, my lord, they have filed a SLP before the Supreme Court, my lord, challenging the order of the contempt application, my petition, my lord, and, my lord, denial of the, my lord, stay order of the freshly filed two writ petitions, my lord. My lord, they have filed the SLP, my lord. Ultimately, SLPs were, my lord, withdrawn, my lord, by them, my lord. In that, the two writ petitions were also dismissed, my lord, by this honorable court on the ground of, my lord, laches, res judicata and sub res judicata, my lord. Only on those three grounds, my lord, the fresh two writ petitions has been dismissed, my lord.
Yes.
Saying that, my lord, the award has already attained finality, my lord, in view of the order passed by the, my lord,
This
earlier.
is 10/12/2021.
Yes, my lord.
Yes.
Now, my lord.
Not, my lord, to all case, my lord. Admittedly, my lord, we sought for the adjournment, my lord, on several occasions. And
Yes.
my lord, adjournment is also, my lord, on the part of the, my lord, the prayer made by the other party, my
So
lord.
you're not ready today?
Yes, my lord.
At
That is
least
my,
you could have a hearing
yes,
and dispose it
yes.
off.
Mary, I'll come
You're
with
not
Mary, my lord.
ready.
Everything is pleaded, my lord.
May I pray that, my
It
if
is
we have
clearly
difficulties
transferred
today,
from
my
the
lord, can
record.
it be, my lord, tomorrow, my lord?
So when will you be ready?
My lord, by Friday, my lord. On Friday, 26th, my lord.
My lord.
Okay, we'll adjourn.
My lord.
For disposal.
Yes, on the prayer made by Mr.
M. Kato, my lord.
Yes, M. Kato, learned
DSA.
DSGI. This matter is adjourned for 26th.
My lord, can it be on Thursday, my lord? Because Friday is basically, my lord, last day of the court, my lord. So, on Thursday, my lord.
We will make it Thursday. What's Thursday's date? 25th?
25,
On
my
20
lord.
yes, on 25. So it's, yes.
Hello.
Your
Deplorable.
Ladyship, I
Yes.
appeared in item number 7. I was trying to speak, but no one could hear me. I appear for the union.
Item number?
7. 7.
7. Okay. The
Yes.
matter has been adjourned.
Yes, your
Okay, so-
Ladyship, it has been recorded that none appeared for the appellant, for the union.
So we'll this thing record your presence, isn't it? Miss
Yes. Tanya Agarwal.
M. Kotari? Dr. M. Kotari, is it?
Tanya. No, for
Tanya.
Union of India, Tanya Agarwal.
Okay, Miss Tanya Agarwal
Ladyship.
appears on behalf of the Union of India.
Union of India. Yes.
Yes, okay. So we've
Your
recorded your
Ladyship,
presence
instead of-
through VC.
Yes, thank you. Instead of 3 weeks, we can also argue in 1 week, Ladyship. We are ready.
We have
3
already
weeks?
passed the order, okay?
All
3
right.
weeks.
Obliged, Your Ladyship. Obliged.
Yes. For the petition, with the consent of the respondents, have prayed for adjournment of the matter. Accordingly, list after 2 weeks.
Yes, Lords.
May I seek your lordship indulgence to mention item number 35, my lord?
35.
Yes, my lord. It's a fixed method, although, my lord, we have just received the paragraphs coming from the department. I've taken in consent from my friend senior counsel, my lord. So can this method be listed after 4 weeks, my lord? We have just received the comments.
You were supposed to file the affidavit, but that is not ready. So you'll
So-
have to post it up after 4 weeks on 24th of May.
Okay, isn't it? There's no urgency. You're for the petitioner.
Mala,
You're
he's
for
for
the
For the petitioner,
I'm
So
for the government side.
petitioner is also praying for adjournment.
No, I'm not praying, he was supposed
But
to.
you're praying for 4 weeks. And he's praying for a short date, so there's no hurry in the matter.
He is asking for 4 weeks, brother. That's
Ah.
why I said let the date be fixed.
Okay, for after 4 weeks.
He is asking
Okay,
for 4 weeks.
not strongly objected, huh? Mister, your good name. I'm coming after a long time.
Yes, yes.
so-
I'm Arish Nabamala, Additional Advocate General.
Okay, Mr.
Arish Nawab.
So learned additional advocate general has prayed for adjournment of the matter since they had received a copy of the affidavit in reply.
No, comments, Mala. Para-wise comments we
Oh,
have just received.
okay,
from the
has
department.
received the parawise comments recently. So you're supposed to file what? The
Affidavit, ma'am.
affidavit.
Yes,
Okay,
ma'am.
has paid,
Affidavit, no.
has paid for further time for filing of the affidavit in opposition since they have received the parawise comment recently. Okay. In view of the above, this is matter after 4 weeks
On 24th of May, Lord, if-
on the 24th May 2024.
My lord, I beg to mention item number 44 to 14. I have for the state respondent and I have taken the consent of the petitioner,
Item number?
4 to 14.
Okay, this is all analogous matters.
Yes, yes.
4 to 14. What is the stage? What were you supposed to do here? 4 to 14.
In fact,
You are supposed to file.
you
a
are supposed to
counter
file,
affidavit.
yes, counter.
No.
affidavit.
Mr.
The Kamdu,
The Kamdut, learned government advocate. What-
Standing Council Land Management Department.
Okay, standing council. Land Management Department has prayed for further time to file their counter affidavit. Accordingly, list is matter after 3 weeks.
After 3 weeks, yes, sir.
May it please your lordship, my lord, in item number 48, my lord, I have filed an additional affidavit, my lord. It may be, I can be allowed to bring it on record, my lord. In 48, I have filed an additional affidavit, my lord.
14,
48, my lord.
48.
I have filed an additional affidavit, my lord. It may kindly bring on record, madam.
48.
48, my lord.
You are for the, okay, petitioner.
I want to bring the affidavit on record, my lord.
Okay, Mr.
I don't want adjournment, just polling slip, my lord, to bring on record on
Okay, okay,
affidavit.
okay.
Oblige the lord.
My lord, this matter is delaying, so my prayer is that let the matter will come up tomorrow.
Which matter?
Delaying, that is, land matter.
Okay.
My please, your lordship. Lordship, in item number 46, my lord, we have filed, my lord, IA.
You filed an IA?
Yes, my lord, that may be called,
46.
my lord, item number 46, we have filed, my lord, IA, that may be called for, my lord. Along with this 48, man, 46, madam.
Okay, so you have made that application?
Yes, madam.
Mm.
For calling of the, my lord, our IA, madam.
Yes, yes.
May I please,
Yes,
Lordship? Lordship, item number 31. Lordship, I am appearing on behalf of the petitioner. Lordship, I may be allowed
31.
to withdraw this writ petition.
Why, let's see, item number 31. Want to withdraw?
Yes. With a liberty to file petition.
Why do you want to withdraw?
Yes,
Why?
some documents we have to edit.
Mr.
D Taba.
B. Taba,
D Taba.
learned counsel for the petitioner, submits that he may be allowed to withdraw the instant writ petition with a permission to file afresh since the documents,
Some vital documents.
since some vital documents have not been enclosed in the instant writ petition. In view of the above, as prayed for, the learned counsel is allowed to withdraw the writ petition with a permission to file afresh. Accordingly, WPC number 50 between brackets AP 2024 stands disposed as above. Yes, as above on withdrawal.
May I please, Lordship? Lordship, I beg to mention item number 2.
Item number
2.
2, yes.
On the last occasion, there was an instruction, a direction to get written instruction from the department. So we need some time to get this instruction. I'm for the department.
Okay, Mr.
T. Gatso.
T.
S for
Gatso.
horticulture.
Learned Counsel for Horticulture Department has prayed for time for
Kindly
filing of
repeat
this
First,
counter affidavit. Isn't
no,
it?
no, only a written instruction that the pension has already been.
Okay, has prayed for time for what? For filing of their written instructions
Yes,
received from the department. Wait, I think there's an order of the court
yes, the last occasion.
in terms, item number 2. I think we should go according to the serial unless it's just simply for adjournment. Okay, otherwise then it becomes a little bit confusing. So we'll let your turn
Let the
come
matter come.
when it's called out. It's
In
only for just adjournments that we'll mention before.
In that case,
May I
Lordship,
please?
item number 55 and 56.
Adjournment,
Yes, Lordship.
you are for the,
For the petitioner. Consent has already been taken.
55 and 56. Mr. So-and-so, learned counsel for the petitioner, with the consent of the respondents, have prayed for adjournment of the matter. Accordingly, list after 2 weeks.
Yes.
May I please, Lordship?
Simply open.
Lordship, with regards to item number 31, Lordship,
31.
liberty may be given. Just now it has been taken up. I have prayed for withdrawal of that. writ.
Yes, yes, with the liberty to private.
Liberty may be given, Lordship.
Yes, I've given.
Oh, deep down.
Done.
Lordship, item number 54, your lordship, may kindly be taken up after 2 weeks, your lordship. I have informed the other side also, lordship.
54,
Lordship,
Mr.
A.K. Singh, lordship.
A.K. Singh, learned counsel for the petitioner, has prayed for adjournment of the matter and that the consent of the respondents have also been taken. Accordingly, list after 2 weeks.
Lordship, please.
May I please, my lord? My lord, I beg to mention item number 17, my lord.
Yes,
My lord, I've taken consent from the other side, my lord.
yes, Mr.
Matter may-
So-and-so,
Matter
learned
may-
counsel for the petitioner, with the consent of the respondents, have
I am
prayed
put a
for-
I am put a respondent, my lord.
Okay, Mr. So where do the respondents stand? On this side or on this side? Mr. So-and-so, learned counsel for the respondents, with the consent of the petitioners, have prayed for adjournment of the matter. In view of the above, list after
After 2 weeks.
2 weeks. 2 weeks.
My lord, I have another mention, my lord. Item number 43, my lord.
43,
Yes, ma'am.
you're for the petitioner,
I am put a respondent here.
respondent,
Yes.
okay. Mr. So-and-so, consent of the petitioners have been taken?
Yes, madam.
Mr. So-and-so, learned counsel for the petitioner, with the, for the respondent, with the consent of the petitioners, have prayed for adjournment of the matter. Accordingly, list after 2 weeks.
3 weeks, madam.
Okay, list after 3 weeks.
My lord, another mention, item number 53, my lord.
53, yes.
I'm the petitioner here, madam.
Mr. So-and-so, learned counsel for the petitioner, with the consent of the so-and-so. Same order, okay? After
After 2 weeks, ma'am.
3 weeks,
Yes. Obliged.
3 weeks.
May I please, my lord? My lord, I beg to mention item number 16, my lord.
1-6.
Yes, my lord. My lord, I have informed the other party, my lord. My lord, if the matter may be fixed it on 13 April, my lord. 30 April.
Mr. M.L. Gope, is it?
On behalf of ML Gope.
Okay. Mention is made on behalf of Mr. M.L. Gope for adjournment of the matter with the consent of the respondents. Accordingly, list after
My lord, if it may be fixed it on 30 April, my lord. 30th of this month.
okay. As prayed, okay, as prayed for, list on 30 April. Yes.
Your Lordship,
I beg to mention item number 57 on behalf of TT Terra. From the respondent side, matter may be fixed on after 2 weeks.
Have you taken the consent of the
Yes, yes.
petitioners?
Yes,
Okay,
yes.
same order after 3 weeks.
From the respondent side. May I?
Wait, don't hurry, huh? What? 3 weeks?
3 weeks.
Okay, fine.
Much-
Yes.
May I? Your Lordship, I beg to mention item number 22. My senior counsel is out of station. So kindly this matter may be listed after 3 weeks. The consent from the other parties has already been taken.
Okay, you are Mr.
MUA.
N.U.B.
M.
appearing on behalf of her senior Mr. Your senior?
Mukpartin's senior.
Mukparti,
Mm.
senior advocate for the petitioners have prayed for adjournment of the matter with the consent of the respondents.
Deeply obliged.
After 3 weeks.
Yes, Your Lordship. Deeply obliged.
Mayor, Your Lordship. Lordship, I beg to mention item number 23 and 24 on behalf of Learned Standing Counsel for the Education Department. He is out of station because of some personal difficulty.
Okay, mention is made on behalf of the Learned Counsel for the Education Department for adjournment of the matter since it's out of station. Accordingly, list after 3 weeks.
Lordship, there is more item number 37, 38, 39, 40 and 41. This,
All for Education Department?
yes, Your Lordship.
So same order?
Yes,
Items number, you said, items number
37 to 41.
37 to 41. Counsel for Education Department is out of station. Okay, adjournment is granted.
Lordship, one more item for the Health Department. Item number 52.
Counsel is where? In town or out of station?
He's out of station.
Okay, same order.
My lord.
Yes.
In item 52, I'm for the read petitioner. Since this is a 2018 matter, may be taken up next week on 1st of May.
When is the counsel for the Health Department returning? Where is he right now?
I have spoken to him. So
Okay. Mention
kindly-
is made on behalf of Mr. So-and-so, Learned Counsel for the Health Department for adjournment of the matter, while Miss
N. Duncan.
Learned Counsel for the petitioner submits that this matter may be listed on 1st May 2024. Accordingly, list on so-and-so.
obliged.
May I, Your Lordship? Lordship, I beg to mention item number 33, Your Lordship. This matter may be listed after 1 week.
Why?
Here, Your Lordship, our senior AAG.
33?
Yes, Your Lordship.
Both are ended longer.
33 and 34, Your Lordship.
Make it
Additional
2 weeks,
advocacy.
after 2 weeks.
Okay.
Miss so-and-so
1 week, Your
Learned
Lordship.
Government Advocate
Yes, Your Lordship. 33
has
and
prayed that this matter may be adjourned.
Lordship,
Yes.
I'm for the petitioner. My senior is here. Can I just give a call? He's outside. I'll call him. because,
Okay, yes, the consent has to be
He
taken.
came from Delhi, so
Lordship, let it come at the regular course.
So, see, the petitioner, counsel for the petitioner has come all the way from Delhi. So let's also hear him whether he objects or not, instead of adjourning the matter when he's here. Okay, so we'll make it a time being matter, it will come up. Yes.
okay.
Oh, this is after this, sir. Yes.
I would pray, my lord, for taking up this matter along with item number 47 and 48. Let this matter be taken up along with item number 47 and 48. It has the similar.
Analogous matters, okay.
Lordship,
Mr. So-and-so, Mr.
Lordship may just skip the matter and call along with item number 47 and 48. Just for time being, Lordship will skip it up. Item number 47.
47 and 48 has been adjourned, I think?
No.
Not yet?
No, my lord. One affidavit has been called for to be taken up together.
Okay, time being.
Time being.
Yes, number 2.
Item number 2. Item number 2.
Some submission was made, so we'll do it according to.
Lordship, I am for the petitioner here.
Yes.
The last occasion instruction were sought from the standing
Instruction was,
Okay.
direction was given. Lordship.
So you have prayed for some more time to get the written instructions.
Yes.
Is it?
On
Okay.
1st May, it may be fixed on 1st May.
Okay. Mr. A.K. Singh, is it learned
Lordship.
counsel for the petitioner is present? Along with Mr.
T. Yatso.
Jesu, learned government advocate.
No, Lordship, standing counsel for the
Okay.
department. Horticulture.
Standing counsel for the horticulture department. The learned counsel for the the horticulture department, standing counsel submits that he may be given some more time to file the written instructions received. He may be given some more time to place on record the written instructions, okay, received from the concerned department. Accordingly, list on
1st May.
1st May 2020.
Deeply.
Mayor Lordship.
Yes.
Lordship, on last occasion, the opposite council were directed to furnish us the IOC guideline, which has been given us this last week only, Lordship. So I need to file rejoinders. I have taken the concern
No,
from
you
the
have to
others.
file your affidavit in reply.
Yes,
Okay, Mr. R. Saikia.
B type audio.
Pardon?
B type audio.
B so and so. Learned counsel for the petitioner has prayed for further time to file his affidavit in reply, submitting that he just received the guidelines for reconstitution of retail outlet dealership. Okay, now in the office note, it says that respondent number 4. None appeared. Who is respondent number 4? Okay, never mind. Whoever it is, anyway, you need further time, isn't it? Accordingly, leave it. Accordingly, list after, when will you be ready?
3 weeks, Lordship.
3 weeks.
Yes.
Number 15.
Private respondent, they have not filed their affidavit. Despite my white order dated 01/02/2020. Last time was given. Despite of the it has not been filed.
Now, in the last order, final opportunity to the private respondents 6 to 9 to file their affidavit in opposition. And so you are for respondents number?
One for the petitioner.
You're for the petitioner. Who's for the respondent number 6 to 9? They're not appearing?
we are for the official respondent only.
They are not appearing. Despite my last time.
Who is the counsel for respondents number 6 to 9? Who is the learned counsel for 6 to 9?
These soon. If file is Wakana Nama, but despite of it, they didn't turn.
What is the matter about, is it affecting the interest?
Yes.
If it is, sorry, excuse me. It is, if it is affecting the interests of the private respondents
Private respondent.
and a wakalatnama has been filed,
This matter can dispose of.
Let me find the affidavits.
you are for what? You are for respondents number 6 to 9?
Yes.
But in the last court date, a final chance was given. What happened? Why aren't you filing your affidavit?
The person concerned is disabled and he cannot move properly also last occasion.
Respondent number?
1.
But we are talking about respondent number 6 to 9. They have not filed the affidavit in opposition. Who is for respondent number 1? Or who are the respondent? The state. The state they have filed their counter affidavit. Now the private respondents whose rights are being affected by this writ petition, they have yet to file their counter affidavit. And we have been waiting for quite some time, it appears, from the orders of this court. So final opportunity was given. Now, are you appearing for respondents number 6 to 9, the private?
6 to 9.
So what do? We give them a real final chance?
Service was completed on 9th of May 2023, 1 year back. Till then,
Address are not properly mentioned there.
The address?
Yes, because in zone of and where they are actually staying.
When did you file your wakalatnama? When did you file your wakalatnama? Quite some time back, isn't it? Then how can you file your wakalatnama if you say the address is not clear?
Because it was appeared in the post list, so I was there.
So now you're not able to contact them or what? What's your problem?
Now I can contact them because now they are free from election duties and also from their respective places.
Okay, we'll give a real final chance. Okay, because last order it was final chance, but you have appeared. Last court date you did not appear. Heard Mr. G. Rima, Learned Counsel for the petitioner. Mr. For the state respondents, Mr. Iram, Learned Additional Senior Government Advocate. Okay, for the state respondents. Present. Okay, heard Mr. So-and-so. Mr. So-and-so is present. Also heard Mr.
T-Shon.
T-Shon, Learned Counsel for Respondents, the private respondents number 6 to 9, who submits that he may be given another chance to file the affidavit in opposition, and further submits that he could not file the affidavit in opposition in the previous court's dates, since he could not contact the private respondents. He submits that he is now in contact with the private respondents and will be filing his counter affidavit by the next court date. Considering the submissions made by the Learned Counsel for the private respondents, this court finds it fit to give another chance for counter affidavit to be filed by the private respondents in spite of this court's order dated 02/04/2024, that final chance was given in the last court date. It may be noted that no further chance will be given if counter affidavit is not filed by the next court date. Accordingly, list on when will it be in? List after 2 weeks.
There is a problem.
What?
Their address are total fake. POPS.
But you have contacted them now, so you can find, isn't it? Huh. Yes.
Lots of this item number 18, lots of last occasion, I have requested a court to this the contempt matter along with but then the contempt has not been listed today. Because lots of this matter is the petitioners have illegally constructed lots of structure after setting fire illegally lots of at the residential building of lots of wildlife Sanctuary lordship.
Okay. Now here affidavit in reply has not been filed yet.
Also, we have filed.
No, my lord, we have to file the affidavit in reply.
Counter affidavit has been filed.
Filed, yes.
Now reply to the counter
Yes.
affidavit has to be filed. Have you filed?
No, no, my lord.
Why? What's happening?
My lord, this,
Because so many adjournments.
yes, yes, my lord.
After time lordship, on top of that, because there is the status quo from this board, but then they are continuing building the structure, so we have filed contempt also.
Okay, contempt is a different matter. It's not.
Yes.
It's not.
But
So that's
since
covered.
construct-
Now you have to file the affidavit
Yes,
in
my
reply.
lord. Due,
isn't
due
it?
to this election, all these petitioner, they were out of station, madam.
Oh,
So only yesterday they have arrived with the documents. That's why we are unable to file
Okay.
today, madam.
This is about election only. From the last occasion,
Mr.
they have been asking for.
yes, Mr.
B. Nyarus.
B. Narrow, learned counsel for the petitioner submits that they may be given further time to file their affidavit in reply and submits that time has been taken to file their affidavit in reply since the petitioners were engaged in election duties. Miss so-and-so, learned,
Cannot be engaged in, they are not officers also.
what,
No,
isn't
my lord,
it?
they were like, they are from far off places. They are election where they have to give their mandate.
Okay, you
Yes,
just,
madam.
for further time,
Yes,
okay,
yes.
further time for filing. Accordingly, list after, when will it be ready?
My lord, 2 weeks.
Lordship, not 2 weeks, Lordship. Since this is a urgent matter, Lordship, they are building the structure continuously. So
Accordingly, list
the
after
officials
1
are-
week.
The officials are pressing me for early hearing, Lordship.
List after 1 week since Miss
Lordship,
so-and-so,
fixed date may be given.
learned government advocate submits that this is an urgent matter. Huh? When will you be able to? After 1 week, you want a date?
Yes, yes, my lord.
We'll
After
give a
1
date.
week, yes.
Lordship,
1 week, a
On
date,
first-
give me a date.
Lordship, 1st of May, Lordship.
First of May.
List on 1st May 2020. Yes.
Deeply obliged, my lord.
This may be recorded that no more adjournment, Lordship.
1st May, let that happen first.
Applies.
Item number 20.
Yes.
My lord, I'm for the petitioner.
Hmm.
Today the other opposite party, they are supposed to file the affidavit in opposition.
Yes.
So I have not received any
Who's the
such reply.
counsel for the opposite parties? Government advocate, is it? Mr. So-and-so, learned counsel for the petitioner is present. It is seen that the respondents have not filed their counter affidavit until date. In view of the above, list after 3 weeks.
My lord, there is an interim order that may be continued.
Meanwhile, interim order passed earlier shall continue till the next returnable date. Yes.
Item number 21. Item number 21.
Mention what is on 21?
None appeared for the petitioner on call. While Mr. So-and-so learned additional AG representing the respondents number 1, 2, and 3 is present. Accordingly, list after 3
After
weeks.
4 weeks, my lord.
Okay, list
I have
after
not
4
even
weeks.
served extra copy also, my lord, 4 weeks.
List after 4 weeks.
Item number 25.
May I please, my lord? My lord, item number 25. My lord, I may be allowed to withdraw the item number case.
You want to withdraw?
Yes, my lord.
Why?
From 25 to 32, my lord.
What
The matter-
happened?
Matter becomes infructuous, my lord.
It has become?
Infructuous, my lord.
Okay, infructuous.
Yes.
Well, what happened during this time? What was the matter about?
My lord, the matter was,
Filling up of posts, isn't it?
yes, my lord.
So during the pendency of this WPC, what happened? They're no longer interested or what? Why are you withdrawing? So many writ petitions have been filed.
My lord, the prayer we made has been already, yeah.
Okay. Mr. So-and-so, learned counsel for the petitioners submits that he may be allowed to withdraw the instant writ petition since the matter has become infructuous. Why? How? Since the petitioners have been appointed or what? What?
Yes, my lord. Appointed, my lord.
Okay, since the petitioners have been appointed. Wait, let me see. What is your writ petition about that you? What is your prayer portion? Let's see. What did you pray for in your writ petition? Because you have filed so many writ petitions and simply withdrawing, what was happening? What did you pray for? Okay, so this was a prayer for appointment of the petitioners. To the post of contractual nursing officers.
Yes.
Is it? So now they have been appointed.
Yes, ma'am.
Okay. Infructuous since the petitioner has now been appointed as prayed for to the post of contractual nursing officers in the concerned district hospitals. Accordingly, as prayed for, the writ petition number 09 AP of 2024 is allowed to be withdrawn on the matter becoming infructuous and accordingly stands disposed of. So this is from 25 to?
25 to 30 and 32, ma'am.
Okay, 30 and 32. Yeah.
Okay.
Item number 36.
My lord, in the last occasion, my friend who is representing the private respondent, he has sought for filing of the affidavit, and this honorable court has granted last chance to him. So therefore, since he did not file the affidavit till date, so this matter will be heard today.
Yes.
My last prayer, Your Honor, since my client, I'm representing respondent number 3 and 4. Last occasion, the last chance was given 1 week. Since for the election purpose, my client, they went to the native place, which is very far away. So I couldn't contact. Yes, last chance, only 1 week. Within
How
1
many
week.
final last chances? Huh?
My lord,
Only 1 week.
Wait, let me see.
Kindly see the result.
Let's see how many times have the court given you a final chance.
It's more than-
Last chance. 3 weeks time to file affidavit in opposition. What is the matter about?
This is regarding this LPC issues. The land is in possession of the petitioner. But they are the private respondent. On the basis of this gift, they are disturbing my peaceful position. And this matter went up to the deputy commissioner. My LPC was subsequently cancelled.
ACP.
Yeah, LPC,
So,
land
LPC.
position certificate.
Okay. So, how are the rights of the respondents affected? Private respondents?
My lord, affidavit is ready, only swearing part is left. Only 1 week.
Heard Mr.
D. Kamduk.
D. Kamduk, learned counsel for the petitioner. Also heard Mr.
Ex Gatti, respondent number 3 and 4, ex Gatti.
S. Sayanti, learned counsel for respondent number 3 and 4. And Mr. R. Iram, is it? Learned additional senior government advocate for the state respondents number 1 to 2. The learned counsel for the private respondents number 3 and 4 has prayed for another 1 week's time to file their affidavit in opposition, in spite of the fact that this court, in its order dated 02/04/2024, had noted that if the respondents number 3 and 4 fail to file their affidavit, the matter will be taken up for disposal without the affidavit of the private respondents. Stop. However, the learned counsel for respondents number 3 and 4 submits that he was not able to contact the private respondents number 3 and 4 since the respondents had gone to their villages due to the elections, and that he will be able to file the affidavit in opposition within a week. In view of the prayer made by the learned counsel for the respondents number 4 and 5, another chance may be given for filing of the counter affidavit. Accordingly, list this matter after 1 week for the it may be noted that no further adjournments will be granted thereafter.
Lordship, may kindly observe that this matter may be listed in this admission column, hearing column, because in any case, he will be filing his affidavit within 1 week.
Let him file first, within list after 1 week.
All right.
Item number 33 and
33 and 34.
Ladyship, this matter, I have received the counter affidavit just now.
Okay.
So as there is some urgency in the matter, my humble request is I may be given a short time for a rejoinder, maybe a week or 10 days. And this may be fixed on any date as a fixed matter in the first week of May. On any date suitable to my learned friends.
Your good name, Mr.?
Yeah, pardon?
Your good name, please?
Abhay Kashyap.
Okay, A. Kashyap, learned counsel for the petitioner is present.
16. No issue. No, 16th is not suitable for matters in Supreme Court that week, 12th onwards.
Since you both are coming from Delhi, so kindly.
No,
you be there.
first week of May, your ladyship. would be
Okay,
suitable.
is present.
Any
along
date,
with
first week.
Mr. Who all are present along with Mr. L. Pamre, is it? Learned standing counsel for the Power Department. Okay. And who else are present? Mr. R.H.
My lord, I am for 1, 2, 5, and 7. my lord.
Along with Mr. R.H. Nabam, learned additional AG for respondents number 1, 2, 5, and 7.
Yes.
And Mr.
Lordship, I am for respondent number 6.
Yeah, good. Okay, for Mr.
Number 6.
And
Six.
Kira.
NG Nab, for respondent number 6. Yes.
We have already filed a counter.
The learned counsel for the petitioner submits that since he has just received the counter affidavit filed by the respondents, he may be given, this
Any
matter
date
may be
between 6
adjourned.
to 10. Any date between 6 to 10.
Accordingly, matter may be, list this matter on
6th May, your lord.
6th
ladyship.
May. and,
As a fixed
2024.
matter, your ladyship,
As
because
a
both of us
fixed
are
matter?
coming from outside.
Well,
Yes. As
my
a
lord,
fixed-
6 may not be possible.
I-
Because my lord, in another my lord matter,
Hmm.
my lord, we are.
For admission hearing, isn't it? Huh.
Yes, my lord. My lord, there are 2 matters, my lord. One matter we have received, another matters, my lord, we are yet to receive any instruction from the department, my lord. So little bit longer that any date after 6, they may choose, my lord.
Give me a
Before
convenient
10th, any
date.
date before 10th, your ladyship.
Any,
Any
my
6th
lord,
to 10th, any
13,
day.
14, any day.
No, second week I am busy with Supreme Court.
All right, then 3rd week,
No, your ladyship, there is urgency in the matter, otherwise let me press
No,
for
so
interim relief.
Make it convenient before the 10th, 9th. What is 9th?
Ninth is a Thursday.
Friday,
9th is a Thursday, your ladyship.
Thursday.
9th.
9th.
Lordship,
Then, my lord.
my availability will be, I have some pre-committed engagements on the 8th, 9th and 10th of May.
6th
So
is fine, your
everybody having
ladyship,
their
for
own
everybody.
problem, my lord.
6th is fine. 7th or 6th seems to be fine.
7th?
7, my lord, I'm sorry, my lord, we won't be able to file the affidavit because we have not received the comments from the department. Then how do we
Oh,
file the
so
affidavit?
this thing, the state respondents are yet to file your.
Yes, my lord, that is the
Oh.
problem, my lord.
Then we'll have to wait for time. So you're prayed for
your-
filing of your affidavit in
Your
reply.
ladyship, I'll file a short affidavit in reply within a week.
Okay,
The
fine.
two matters are identical. The two matters, my learned friend, they're absolutely
But they
identical.
need time, isn't it?
They
So,
can, but
uh,
your lordship, on interim relief, we can argue on, or your lordship may allow me to press for interim relief on 6th. Your lordship, they were given time.
But if on 6th, if the states have not filed their counter affidavit.
Yeah, I
till date,
understand your
then
lordship.
How can we, this thing?
Your ladyship, the order of 21st to 24,
Hmm,
the last para very clearly says
Let's see.
22,
21 to 24.
21 to 24.
Yes.
The last para, your lordship, I read. Since
Yes.
urgency has been expressed on behalf of the petitioners, it is expected that before the next date fixed, the pleadings would be exchanged. This did not happen, your ladyship.
Hmm.
This court will also consider taking up the entire matter of final disposal at the admission stage if found convenient. So, your lordship, there is a question of some urgency. I am willing to waive off my right to file a rejoinder in the second matter. They may file their counter in the meantime. I'll file one rejoinder in the matter in which I have already received the counter affidavit, and we may go for final arguments.
My lord, what
Will
is
you
the
be
urgency,
prepared?
my lord? It's a
The
matter
urgency,
pertaining to some
your ladyship,
compensation.
the urgency is a matter of land acquisition.
Yes.
Where work has already started.
Correct.
And your ladyship, I am not even going to press for stay.
Hmm.
I assured the bench that I am not going, but your ladyship, the due process of protecting the rights, extremely arbitrary orders have been made, your ladyship.
Well-
And our order has been made saying people who do not have any rights will be given so much compensation, arbitrary. And
Well-
people who have rights, no mention of.
Well, I'm sorry to interrupt, my lord. In this case, my lord, land acquisition will not apply because
No,
it's an electrical line.
that's-
So
that's
whether
the-
line, my lord.
it applies or not, that has
your-
the matter has to be seen,
Yes,
isn't it?
your ladyship, all I am
Basically,
saying.
they're harping on that
Your-
only, my lord.
No,
Land
your
acquisition only,
ladyship,
my lord.
all I am
Which
saying
our
is,
stand is that
your
it will not
ladyship,
apply.
I'll show your ladyship, there's 100 acres in the total project land acquisition, where power towers are put on, your ladyship, there are two types of land acquisition.
So it appears that you're thorough with the matter.
Yes. Proper pleadings are required, my lord. So until and we get the instruction from the department, but it will be very difficult for us to
So
assist
what
the
is the
court. ma'am.
position right now?
The
Acquisition
position
is
right now, work
complete,
has started, your
work
ladyship.
started,
And
road
no
construction is.
survey has been done of any kind. Your ladyship sometimes, no, it's not road, your ladyship, it's a power transmission line.
Okay,
In transmission line, what
Ah.
happens, your ladyship, there are two types of
So
compensation
power
that give.
transmission is
So
going
one is
on.
where the line goes,
Ah.
is the defrayment of the quality of
So
land.
where are the petitioners right now?
The petitioners are right now, their land has been taken over for power transmission. Now, what happens in power transmission? There is a certain rate fixed for the area where the tower is. Let's say, I'm just giving assumption 25 square meters.
Hmm.
And there is a rate fixed for the line where it goes because of the power, there's a duration of the quality of land.
My concern is, you're saying there's urgency in the matter.
Yes,
So
because
are they dispossessed of the land?
they are
or
dispossessed of
something is
that portion,
happening?
and the sites are being destroyed because whatever is there on the 25 meters or 26 meters where the tower will be put, that is destroyed. So there will be no way of knowing what was there later. All I am really looking for is a mechanism by which the rights of the present people who are in possession, who have been denied possession, not only have they been denied possession, an order arbitrarily sitting in a room has been created saying that it is not required to do any survey in this area because this is reserved forest land. So the entire matter coming under the FRA 2006 Act has been disposed of by an administrative order. Your ladyship, your ladyship needs to look into thoroughly.
We have to look into
I-
whether
I
it is
only-
reserve forest area or not.
Yes,
That
yes.
has to be looked into, is it?
No, ladyship, my humble, that he is right.
Because it
He-
is reserve forest
he is
area.
right.
That's your stand.
Your
isn't it?
ladyship, I agree totally with him. I totally.
I am the project management consultant. I
Oh.
am a union, government of India. So one, I'll just,
So you verified whether it's forest area or not?
It is forest area, Lordship, that's not disputed.
Oh.
Lordship, there is no question of land compensation in the erection of towers or stringing of line thereof. The law is very settled.
So we'll have to look into that.
I'm saying the same thing, Your Lordship. I agree with him.
Now.
But there are two types of compensation.
The policy decision itself reads. It is an ex gratia payment being given to people who are otherwise not entitled to anything in respect of a reserve forest.
So we'll have to look into that.
Your Lordship,
matter.
I will show your Lordship.
So in the next stage, you
Yeah.
file the affidavit in reply to the counter affidavit filed by respondents number number six.
Both the petitions.
Okay. In the meantime, the state government is still
Unless we
silent.
file the affidavit, my lord,
Ah.
the pleadings will be not clear, my lord.
Yes, so the
Absolutely.
state government will have to file
Absolutely.
also.
Because we are only executing.
They are
on
only
their behalf.
executing agency, my lord. Until and unless state going to file the
So we'll have
affidavit.
to give them some time.
Okay, Your Lordship, but it may be fixed for.
Okay,
final
heard
hearings
Mr.
and-
So-and-so,
My
learned
lord,
counsel for
somewhere
the
in
petitioner,
20
who has prayed for time for filing of the reply affidavit to the counter affidavit filed by respondent number six. Meanwhile, the state respondents are to file their counter affidavit list
on 20, my lord. 20,
on
20th May,
20.
my lord.
Okay, that's fine. 20th May is acceptable.
20.
Yeah,
20.
20th May.
20,
20, my lord.
5, 2023, yes, 2024.
Your Ladyship, better will be, yeah, 20th May is fine, Your Ladyship.
20, on the
20th
20th,
May.
20th May.
Yeah,
correct.
it's acceptable to them, it's okay, fine.
Both, my lord, both the items, my lord.
33, 34.
Yes, for
But
both.
Your
Same
Ladyship,
order.
I have one humble request. In case there is a delay in filing of counter affidavit, as has been my experience for years, I may kindly be heard on interim relief on that day. Because their counter affidavit is already with me, my rejoinder will.
In your writ petition, have you filed for
Yeah,
an?
Your
prayed
Ladyship,
for an
we have,
interim?
we have prayed for interim.
Okay.
Yeah.
is there?
No, the main.
And in case counter affidavits are not filed by the state respondents, as prayed for, this court will consider, will make it consider, okay? A hearing on the
Okay, I can only expect
interim,
consideration.
interim relief prayed for by the petitioners.
Your Lordship is being very kind when you say consider, I can't expect anything more. Much obliged, Your Lordship.
Item number 42.
My pleasure, Lordship.
Yes.
Lordship, I have instructions not to press the matter.
42,
Yes,
but you are for the
petitioner.
petitioner.
Yes,
So you want to withdraw?
yes, I have instructions to do so.
But what is the petition about?
The petition was about
did you come?
appointment, Lordship.
So have you been appointed or?
No,
you are not
Lordship.
willing to
No,
enforce?
Lordship.
They must have come to some compromise, good?
No, actually, she wants to file another petition, bringing in some other materials on record, which was not brought in this case.
Okay.
Hmm.
Heard Miss
And Duncan?
and Danke, learned counsel for the petitioner, who submits that she may be allowed to withdraw the instant writ petition since the petitioner is no longer interested in pressing the matter.
Liberty of may be given. Lordship.
The learned counsel submits that she may be allowed to withdraw the instant writ petition with a permission to file with a liberty to file afresh if so advised.
Obliged.
Accordingly, so and so is allowed to be withdrawn with a permission to file afresh if so advised. Do we want to reflect your name? Okay. WPC number 602 within brackets AP 2023 stands disposed of as above.
Much
On
obliged.
withdrawal. Yes.
Item number 44.
May I, my lord? May I, my lord?
Yes, yes.
My lord, I'm for the petitioner appearing on behalf of the conducting counsel L. Parme, my lord.
Oh.
The respondent is yet to file the affidavit, my lord.
You're for the petitioner.
Yes, my lord.
None, you are Mr.
P. Sring, my lord.
P. Shrime appears on behalf of his senior, Mr.
L. Parme.
El Parme. I can't pronounce your name, sir. El Parme. None appeared for the respondents. Wait. Now, the office note indicates that service report upon respondent number 4 is still awaited. None appeared for the respondents. The list after
2 weeks, my lord.
2 weeks.
Obliged, my lord.
Yes, this is a contempt case.
Descending on 6th April, I have so 4 weeks time.
Mr.
Yes.
Ex-Seti appears on behalf of respondents number 1 and 2 and submits that he may be allowed time to file his show cause reply. Accordingly, list after 4 weeks.
Item number 47 and 48.
My lord, this item 46 was also there.
46 is also to be heard. 46, 47, 48, is it?
46 on a different issue, 47 and 48, along with item number 1.
Yes, something we had mentioned. Yes, item number 1. It's all connected, you say.
Yes.
Isn't it? Yes. What's the matter?
147 and 48.
So now we'll deal with 47 and 48 first.
48 first, 47, 48 first.
47 and 48.
Lordship.
Yes.
47 is the miscellaneous application filed for interim direction. And
This is 19.
before that, if your lordship takes up the item number 48, the facts of the case would govern. May I submit the facts in nutshell, my lord?
See, now here it says that office note says last order was that affidavit in opposition is to be filed. What is the IA about?
My lord, the affidavit has been filed by the respondent. But in the IA, my lord.
In the IA, what is the IA about?
My lord, IA for certain direction to my lord, pay the amount to the my lord, petitioners. My lord, before that, my lord, the facts of the case in 48 is such, my lord. One, my lord, Velacha, the respondent number 7, my lord. He was the contractor in respect of construction of a road under the border road organization.
Wait, before you continue, the IA is for item number 47 and 48. So what it says for only the IA has been put up.
That's it, my lord.
So it has to be with WPC number 3 of 2024.
Yes.
IA is arising out of
3 of-
WPC number 3 of
3 of
2024. The WPC is not here, only the IA has been put up.
WPC is item number 48.
Yes, WPC, yes. Okay.
Madam, for the purpose of consideration of the IA,
Yes,
may I
that
submit
is
on the
all.
facts of the main case, madam, that is item number 48. My lord, facts in nutshell is that, my lord, one Velacha, my lord, who has been, my lord, implemented as respondent number 6, he was awarded with a contract for construction of a particular road, my lord, by the BRO, Border Road Organization. And as per the terms of the, my lord, agreement, the present petitioner was, my lord, approved as a subcontractor. There is no PVT of contract between the present petitioner and the BRO. BRO is the employer.
Yes.
LHI is the contractor. They have a contract agreement. And in terms of one of the clause of the contract agreement, the present petitioner was, my lord, appointed as a subcontractor to execute the work to the extent of 49% of the total works. That means subcontractor cannot execute more than 49% of the total works. Now, due to the, my lord, various, my lord, the hurdles come on the way, either created by the BRO or by the valecha, there are certain delay in execution of the work. But nonetheless, I have completed the 49% of the available work that was given to me.
Yes.
Now, in the meantime, due to delay in execution of the work, the principal contractor had submitted an application for extension of time as per the provision of the contract agreement. So that application for extension of time was negated by the BRO, and moment they have, my lord, negated the, my lord, extension, I have submitted my request before the respondent BRO that I have executed this much of work. You give me this work, the amount that has been covered, and rest the performance bank guarantee and other interim payment, whatever has been there, you pay me without deducting any liability, because I don't have a contract with the BRO. The entire contract is between the valecha and the employer BRO. And the terms of the approval is also, though I'll be then subcontractor, the entire responsibility will be on the valecha, that is the principal contractor. Now that having not been done, I have approached this court. In the meantime, due to my delay or the contractor's fault, the entire work has been terminated. I am not against the termination of the contract.
But you have done your part.
My part.
That's your
amount.
submission.
To the, my lord, they have made a, my lord, in the letter by which, my lord, intention of, my lord, termination was issued. They have mentioned that up to the month of April, I had executed 26% of the work. And till September of 2023, I have completed 49% of the work. So therefore, principal contractor has said that now give me the 51% of the work I'll execute. Because 49 will be executed by the subcontractor, 51% will be executed by the contractor. Now, at this stage, they having not come up with any response to me. On the other hand, they are intending to deduct the various damages from the bill. I have approached this honorable court. And this honorable court, by an initial order, directed them, the BRO, not to encash the performance bank guarantee to the extent of 2 crores and odd.
To Valencia.
No, that was deposited by me.
Okay.
That was deposited by me for the 49% of the work. So in first interim order was to that extent that this bank guarantee would not be encased. Now subsequently, I have filed a miscellaneous application that this amount I have borrowed from different sources and I have a lot of liability, and since the work executed by me, you have accepted it. So you measure it and pay me the bill.
The bill. Okay, so this is the IA about.
This is the IA about. Now in the IA, an order had been passed by this court directing them to furnish the reason why a joint measurement cannot be taken up and the payment cannot be made. That last order, order in the IA,
yes.
Order dated 4/3/2024. Second paragraph, if your lordship.
Yes.
Lordship. Mr. M. Kato learned this DSGI appearing for the respondent number 1 to 4 shall file an additional affidavit on behalf of the respondent number 1 to highlight as to why the payment for the works as done by the petitioner as subcontractor duly approved by the authorities shall not be released to the petitioner directly after conducting a joint verification on the part of the works as executed by the petitioner. So now they have filed an affidavit. This affidavit contains nothing. It only says they don't have a PVT of contract with me, but this valecha, respondent number 6, as per the terms of the contract, he has to submit an application for termination payment. And the valecha was invited for a joint verification. He did not.
So where's the affidavit filed?
Lordship, my lord.
It is not here in the file?
My lord, that affidavit I have annexed along with the item number 1. Before that, my lord, may also.
No, have they filed? Have they filed?
Filed it, my lord. I have also.
The additional affidavit.
Lordship, my lord.
In terms of this court's order dated 04/03/2024.
Lordship.
Is it filed?
This is filed, my lord.
As per the office note, dated 12/04/2024, affidavit has not been filed.
My lord, this has been filed. I have also, I don't know whether they have filed.
But it is not.
But I have been served with a copy.
When were you served a copy?
And I have, my lord, enclosed it, my lord. At page 83 of the item number 1. Page 83 of the.
Okay, so now we come back to item number 1.
Yes. Before proceeding to that, my lord, may I submit, my lord, why the item number 1 had to be filed, my lord? Now, Lordship has seen the order of this court directing them to file an affidavit as to why the joint verification cannot be done with the petitioner and pay the bills, whatever works is in the IA. Then I have submitted a representation before the authority that as per the order of the court, you make a joint verification and pay me the bill. They, instead of doing it, they have rejected my petition, saying what in the affidavit they have said, and what they have done, they have floated the tender, fresh tender. Because the earlier contract was terminated, and in the new tender, they have mentioned the balance work of particular road. Rest is everything, only the word balance is mentioned. Now 51%. 51% ought to be. Ought to be. But what your lordship will find in the first, the NIT, pursuant to which respondent number 6 was awarded the contract, the amount was 67 crores and odd. And I have completed 49%, that is something about 33 crores and odd. So, my lord, the balance should be somewhere between 30 crores and odd. Now, in the second tender, they have made it for 54 crores.
Yes.
Meaning thereby that they, before floating the tender, they have not measured what is the balance work, number 1. And number 2, if this contract is settled and the new contractor is handed over with the possession, the very evidence of mine executing the work. I'm sorry.
You should have some water.
Yes.
Yes.
But pursuant to this NIT, this second NIT, if the new contractor is awarded the contract and he has been handed over with the possession, the very evidence of me executing the work to the extent of 49% will be.
Excuse me, my cup. Oh, okay. Yes. So now what will be the stage?
So
The
now
respondents will have to
Madam,
respond.
so far as the second, the item number 1, where I am challenging the second petition, the second NIT. It is basically, I don't want to say that you should not go ahead with the construction.
The dismissed.
You should not go ahead with the distinction. That is not my contention. You may go ahead with the construction, but the work executed by me and for the purpose.
So they have to file the affidavit in opposition.
I'll come to that. On the last occasion, when I had prayed for an interim, they said they want to obtain instruction. So in the first item, they were directed to obtain instruction, and the interim prayer.
Yes. I have these attacks now and then they goes.
Let's take a break and come after 10-15 minutes. So let's relax. If your Lord wishes.
It's okay.
Proceeding can be restarted at 1 also after 1 hour. So let's check.
How many cases do we still have? I think we are almost finished for the morning.
These two matter perhaps will take time because they will also.
But there's nothing in writing. So are you going to pray for filing of the written counter affidavit? You have filed. So we're going to hear the matter. Is it?
First one,
Item number 1.
But won't these two items be clubbed together? Or it's different?
My lord, this
To
has
some
been-
extent, they are being referred together.
Yes, therefore, my lord, since my lord, this item number 48 was already fixed earlier. So the first matter was fixed today. It was moved earlier. It was fixed today so that both the matters can be taken up together. And therefore, my lordship is taking up item number 1 and 48 together.
So they should be clubbed together actually, isn't it? Because in item number, item number 1, it is concerning, you're saying the remaining number of works, but the percentage is too high, you're saying. Isn't it? Item number 1.
Right.
In item number 1, for the matter, to finalize matter impact, NIT,
Okay. Before disposing of this WPC.
Right.
And
Deciding this.
Petitioner is playing for another joining another SSB.
For the works already done by him, he wants the payment, isn't it?
And for that purpose, measurement is required. So joint verification by the department.
Of course, under the proposition, 49 works will be allowed to subcontractor and the 51 will be executed by the main principal. And in that case, they are claiming for the deeds for the work executed
By them,
by them.
49%.
49% in it. They are claiming that more than 49.
We will confine to 49.
They are claiming.
So we are saying 49, not more?
49%. In fact, my lord, they should pay me whatever I have worked. If it is exceeded 49, they should pay. If they said, no, you cannot execute, I'll confine to 49, my lord.
49%. So what's the dispute then? If you're agreeing that it's 49, you're agreeing that 49% has been done?
For that verification would be necessary.
That is the matter of the department.
Okay. So have you done your verification? Are you saying that 49% has not been done?
Well, at
Okay.
this stage,
You're
if your
saying you
lordship-
have completed 49, the department is saying you have not completed 49.
So therefore, the joint verification is necessary.
So
to
did
accept-
you do any joint verification?
They have not done the last order. They have directed why cannot be joint verification cannot be done. In the affidavit, they come up with no plea except saying that they have a contract with Velacha. At this stage, if the interim order is passed to the extent, my lord, that
Joint verification
joint
be done. Can you
verification-
do that?
and till joint verification, the tender in item number 1 may not be finalized. I am not saying for the stay of the tender notice. Because once the person who will be awarded contract under the item number 1, if he takes the position, I have already executed the work. Now he will just measure and submit the bill. And my bill will be taken by him. That is the whole cracks of the matter.
The main issue is the petitioner is not privy to the person, it is the department. The principal secretary is somewhat different. Who is not
So I think this Valencia should also be present.
Notice was
He's
issued
not
by the-
been made a party.
He's been made party. My
Then?
lord, what happened to Velacha? Velacha, whatever benefit he could take, my lord, he has
He's
left.
disappeared.
He has left. Now the bills what are pending is mine. The performance guarantee, whatever submitted is mine. So he
So
has,
do you have a written agreement with this Valencia? What's his name?
yes,
Valencia.
Velacha, yes, ma'am.
So
Yes.
do you have a written agreement with them?
We do have.
You have.
We have. And the authority, they have accepted that, my lord.
And the department is not directly having the agreement with the petitioner.
That is their contention. And I said,
That you have given this thing.
And I say, my lord, there's no requirement of, my lord, any written agreement or verbal agreement. I have executed and work, and I have executed duly because you have approved the subcontractor.
You see, the problem is this, Valencia can also say, this is what I did, not you. You see, Valencia can say that when you're claiming the 41%.
That's it.
Okay, now the additional affidavit filed in item number 48 is just produced before the court today.
Bias. Well, this has been filed as to show on the ground that we have executed work, only to, my lord, a supporting document before your lordship. The
You have a
photographs,
copy of the additional affidavit?
various photographs I have annexed, the bills I have given, my lord, only to show that, my lord, the for coach perusal, my lord, that the.
But Valencia has been made a party, isn't it?
Yes, yes.
In the case. So in the IA also, are they made a party?
Yes, my lord. Yes.
Then we can pass an order for the three of you to look into
Valencia
the
would
matter.
not, will not
But who's representing this thing, Valencia?
Madam, Valencia, they have invited to go for joint verification. As I said, Madam, he ran away. I am a local contractor. I cannot run away. I have executed with the hope that 49%, if my lord, work I execute, I'll have my credential to go for a bigger work.
Where has he gone? Run away means where? He must be having some address.
They must be having, but then it is on their volition. They are not contesting because they are not going to suffer anything. All the money part is involved. It is mine. And in fact, they have submitted their representation also that I have executed 49, that 49% work I have completed, my lord.
They have made a letter,
Yes,
formal
yes,
writing?
yes. Lordship, may kindly have that document, my lord.
Now this additional affidavit has been filed in WPC what?
3. In WPC number 3, your lordship may kindly come to, my lord, the particular, my lord, approval at page 48 in WPC, my lord, 3, 48. This is the approval, my lord, by the BRO. 49, my lord. Paragraph 3. The proposal has been examined in the light of provision under clause number 4.2 of EPC agreement under CA number so-and-so. The proposal submitted by a firm to allow Messrs. Petra Dampon Enterprise B sector, that is present petitioner near Rajbhavan so-and-so Arunachal, to execute the subject work as subcontractor as in principle agreed for the subject work to condition that subcontractor.
You're reading from where?
Page 49 of WPC number 3 of 2000.
Not the additional affidavit.
No, the WPC main petition. 49.
See, now this Valencia, the agreement is between you and Valencia. And the state were not involved in the agreement between both of you.
Yes.
So now you have made the Valencia a party. So this joint verification, I think Valencia will also have to be there to confirm.
Valencia was invited by them. He did not come. Had he went, my problem would have been solved. He will not go because he doesn't want to come to the ground now because he had cheated me. He had cheated the government as well. They have issued numbers of letter from their affidavit also, it says.
So if they don't appear, then whatever happens.
They have admitted that I have executed 49%.
Where have they admitted?
Yes, Lordship may kindly come take up the WPC number 3 of 24, and Lordship may come to, my lord, page 90. 90. This is a letter written by the Valencia to the chief engineer, BRO. Now it's a detail, my lord. I'll just take your lordship to some of the, my lord. Page 93, if your lordship comes from it. Page 93.
Yes.
Paragraph 9.
Hmm.
It is evident from the record that an amount of rupees 19 and odd crores scope of work is not approved till date for realignment of roads so and so. If the authority would have envisaged the alignment problem during DPR stage, then the EPC contractor should not have deprived from executing the above work, keeping idle of the manpower and so and so. Therefore, the authority should compare the percentage of work done with available scope of work. In this instant case, it is 67 crores and odd thousand, and minus 19 crore comes to 48 crores and odd. Then your lordship may come to page 96. Therefore, an amount of rupees 628.83, as your lordship got it. Therefore, an amount of rupees 628.83 so and so is to be billed against work done, and the percentage against rupees 48.45 available scope of work will be 12.98. Hence, the percentage of work done will be 37 plus 12.98 is equal to 49.80% as against present scope of work. That is done by me.
But where does it say that it is done by you?
Well, this is because this is 49% I have subcontracted, and thereafter they submit this letter at page 112. Your lordship will come to page 112. Construction of so and so subject work program for at least 51% of contract price by EPC contractor so and so. With reference to the caption subject, please find here the work program mobilization plan and plant machinery laboratory equipment so and so for rupees so and so will be executed by main contractor pursuant to article 4 of the clause so and so. So this is the 51 they want to execute. They said 49% has been done by the subcontractor. That is me.
Where is it given?
Yes, then my lord will have to.
Where do you mention that it's been done by you? That's the whole thing.
Yes, 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 yes.
Valencia has to admit that you have done the 49%.
No, because Ilochivia has seen 51%. They have given me
51 they
49.
say. But now I can understand this position of the state respondents, since there's no agreement between both of you to release such a huge amount. You're a third party who were not there when they agreed with Valencia. So unless Valencia is made a specific statement that 49% was done by you and they will not claim anything, then it becomes a little bit risky. Now, then they said that a tender has been floated, which is more than 49%.
Yes, more than 51%.
More than 51%.
And there should remain 51%, but the amount they have shown as if it is something about 70%. And thereby,
then there could be an issue in that, unless Valencia somewhere in their documents have clearly stated that 49% was done by you as per their agreement between both of you in their letter dated so and so. Then the state respondents will have the assurance, okay, when Valencia is admitting that so much has been done, then we can release the money to you because you have done. But you're not finding any document for that.
Well, this so far is the approval that at page 49 I have shown. That is on the volition of the Valencia. They have submitted an application that the present petitioner should be accepted as a subcontractor to execute the work. And accordingly, the authority approved 49% of the work to be executed by the present petitioner.
Where's all that?
It's 49.
49 is only in as per year. Okay, 49. This is
approval letter by BRO.
Approval of subcontract.
That's it.
Yes, so the state has approved.
Yes, my lord, to the extent of 49.
Or you do 49%, isn't it? So based on this letter, your approval, without Valencia, you can see whether the 49% has been done or not.
Well, at this stage, my lord, joint verification is required without my lord ascertaining how much percentage, because I am saying 49, they are saying less. So once the joint verification is done in between by both the parties, then it will be ascertained whether it is 49 or it is 42 or 27.
So if you look at page 48, 49, annexure E, here you have approved. You have approved that this Peto Dumping Enterprise, okay, would execute the work as subcontractor. So here you have recognized the existence, isn't it?
Then first we are denying.
Huh.
Versus what we are denying.
Yes. Wait, where's the affidavit filed by the department? Let me see. Affidavit filed by respondent number 13, yes. Yes. What are you saying in that matter? Huh?
Paragraph, specifically, paragraph, paragraph number 5.
Yes.
Then with regards to the statement made in paragraph 3 of the petition, the state said, by MS Peto from whom there is a work of executed more than 49%, whereas the total reported progress of the work of the specification case of the only 6.21%, for which the payment has been released to the contractor. No further deed has been submitted by the contractor regarding any further progress of the work on ground. Should better to the timely payment of this and further in this range. It should be the Valencia hearing located and the communication capability to the federal component by the
So they're saying that no bills have been submitted.
Like,
yes, yes.
So in annexure 5, the
Hmm.
whole portion. The valuations of the unbilled and the partially the completed work, as per clause number 12, so the contract agreement has been carried out and the payment due if any after making the deductions for the achievement of the milestones, non-rectifications of the deficits and the other associated deductions will be made to the respondent number 6. I love that is respondent number 6. The other submission of the legal documents as per the contract agreement by the respondent number 6. The petitioner claims to have not received the payment from the respondent number 6 on their internal matter as per their mutually agreed MOU and so. And this department does not have any say on the matter. I'll pause for a moment. This matter, madam, so far our affidavit, madam, before filing of the official affidavit, madam. This is our complaint, so the date is admittedly unbilled. The work, the work executed up to date is unbilled. Now, madam, by this additional affidavit, madam,
We have brought on those.
Bill has been raised, madam, some to that extent that the work they have executed. They have raised,
In the additional that the bills have been submitted, yes.
So therefore, this matter, by additional affidavit, madam, artist was not brought to the notice of this court.
So you have to check the bills first.
So therefore, madam, this is the matter, madam.
Yes.
No,
Yes, with the additional affidavit, correct?
Yes, yes, my lord.
But ultimately, you have to see,
No, my lord, my whole thing
there
is
shouldn't be double billing with the new tender that is floated
that
and
should not
work
be double.
already done, that you have to be careful also. So this is also in your interest. Now, when it's claimed that 49 is already done and the new tender in item number 1 floated is maybe about 60%, then it is in your interest also to see if the work has been done, isn't it?
Very clear. 22.21% work executed by the petitioner. It is released. If there is unclaimed bill, the unpayment, unpaid bill, and the unbilled amount,
So what happened to the 21% released? They're saying that 21%.
That 21%, that is different,
21%.
different stage of payment. Up to 6 stages, that is 26.21, they have released. They have
released, and you have
this work
received.
This work was executed till February 23rd. Well, Lordship, may kindly have a look.
So you have received some money?
My lord?
You have received some money?
Yes. Ma'am. Some money I have received. Now whole thing is that that execution was page. Lordship, may kindly have a look to page 81. My lord. Just for I'll clarify this portion, my lord, of 26%. Lordship, may come to page 81. This is their letter. My lord, notice
81 of your?
Of my repetition. This is a letter, my lord, intention of termination issued to Velacha. Now your lordship may come to page 83.
Yes.
The second milestone, if your lordship in the chart, if your lordship find serial number 2, milestone 2, 27th April, the work progress should have been 35% and amount in crore should have been 23.74. Whereas I have done 26.21. This is 26.21 they are referring to. That is up to, my lord, 27th April 23. They did not stop my work. I continued the work. Only in the month of October, they have, my lord, terminated the contract. Now, in between this period, the SP8, that stage payment for SP8 comes. This is up to April. They have issued the termination order of the contract, my lord, only on 16/12/23.
There's no arbitration clause or what in your
I will not be governed by the arbitration because I am not a PBT to the contract. My whole case is on the section 70 of the Contract Act.
You should have been made a party, then you could have gone for arbitration, isn't it? Anyways.
The agreement I don't have, so I cannot be a party to the contract. But my whole contention is as per section 70, my whole claim is based on section 70. But this section 70, what it says, whether 3 conditions one has to fulfill, whether you have an agreement or not. Access given Y to execute a work, whether there is an order or not, but there is an authority for me to execute the work.
As a subcontractor, isn't it?
Yes, here in this case, subcontractor. And I have executed the work. And access received the work. Whether there is a contract or not. 3 things has been satisfied that I have executed the work.
I don't think the state is also hesitant to pay you for the money, but you have to find out what has been paid.
So therefore, my whole thing is that perhaps this will not affect the interest of the respondent as well. But why they are avoiding of having a joint verification? Lordship will kindly consider for issuance of the second tender also, it was incumbent on their part actually what is the balance work. Now I have completed 49%, as good as 50%. So the tender amount should have been 67, half, it would have been somewhere 32 crores, but here 54 crores. And the new person who will be selected, he'll just measure and submit the bill and they'll siphon out the money for which I have told everything. So to preserve that things, my lord, my submission that let there be a joint verification. They are saying 26, I said 49. Once joint verification is taken out, it will be clear how much work I have done, number 1. That will also facilitate them for the second tender, what amount that should have been.
So, but this joint verification has not been done till date in the IA.
Yes.
Okay. In the meantime, you have filed this additional affidavit showing the bills. Which have been submitted. When they say it's only this much, but you're saying you've submitted so much bills, isn't it?
Something I have not annexed. Does it mean they'll deny it? Does their record doesn't say so? Should they say that I did not submit bill when I submitted the bills?
So maybe, so you have to, but you have to make your point, isn't it, that I have submitted?
Yes.
Then let them verify and say. Let them verify and see. Now you have your.
Let them go ahead with the bills. That is with regard to payment. Now I am not with regard to payment at this stage. Payment will come at a later stage.
Okay.
Now things will, how much work I have done. So that can be ascertained only by a joint verification. And that will not hamper the interest of the respondent as well. And that
Now,
was,
the IA
and
is
that was the-
concerning the joint verification,
Yes,
isn't
that
it?
was- that was
Which has
the-
not been done.
not done. And that was the intention of this honorable court while passing the order dated 4/3/2024. You file an affidavit why you cannot have a joint verification and pay the amount. They did not come up with any response. So at least let them have the joint verification so that my very evidence.
Should we fix a date for the joint verification to
Yes.
be held? Any problem with having a joint verification?
That is the only way, my lord. They are saying 26, I am saying 40. Unless
In the
this
meantime, in WPC 3,
should not be finalized. my lord.
you find your counter to the additional affidavit. And in the IA, what is the difficulty in having a joint verification? Because you have acknowledged that certain work will be done by the instant petitioners in what the letter which you have just read, you have allowed. So you check and see whether 49 or whatever person, they have done any work or not. Because you're saying that we cannot have joint verification because they are not the party.
Yes, that is
You
the
don't have any agreement with them, isn't it? But you have acknowledged their existence in one of your letters where you have allowed, isn't it? So we'll pass an order for the joint verification to be held within a certain time. In the meantime, you this thing this. Isn't it? So you talk to your to see what. Okay, we'll continue in the afternoon then, if he's around
That's
at 2.
that's
He's around in the premises. So you find out, get some instruction on this in the IA. And in the meantime, in the WPC, your additional affidavit, you'll have to find a counter, if any, isn't it? The IA, in the WPC
And in that-
3,
and in that,
WPC 3.
Yes, well, in that I'll renew my prayer for interim, not to finalize the tender. Lordship may not stay the tender, let the process go ahead, but not to finalize it. Because
That will be in item number 1.
1.
So let's do 3 first,
Yes.
isn't it?
Yes.
Heard Mr. PG Saikia.
Yes, madam. Till then, my lord, that's what I'm saying.
Okay, let's dispose of item number, what, 48, is it? WPC 03, okay. Heard Mr. PJ Saikia.
Lordship, assisted
Okay,
by-
assisted by
Yes, Mr.
Learned Senior Counsel, assisted by Mr.
Actually, I'm assisted by K. Lolan there.
Okay, K so and so. Along with Mr. M. Kato, learned DSGI, appearing for the state respondents. Okay, 1 to 4. And Miss P. Pangu, learned government advocate for respondent number 5. Just seen that the petitioners have filed the additional affidavit and the learned counsels for the respondents have prayed for time for filing of the counter affidavit. In view of the above, list after 3 weeks. This is in WPC 3. Now in the IA,
But can there be a date, my lord, on 15th? Because another matter of mine is fixed on 15. I'll be coming.
okay, after 3 weeks on
15th of May, my lord.
15th May. Is it 3 weeks then? Okay, list on 15th May, instead of 3 weeks, 15th May. Now in the IA, we'll do this in the afternoon. You have got to discuss the matter with the officer, isn't it? The IA, concerning the joint verification. When can it be? So time being matter. Now in the item number 1, of this WPC 165. Okay, okay. Okay, will please order for this. Heard Mr. B.J. Saikya, learned counsel for senior counsel assisted by Mr. So-and-so for the petition, along with Mr. M. Kato, learned deputy SGI, appearing for respondents number 1 to 4.
3, 4, 5. 1, 2, 3, 4, 5.
1 to 5. Okay. The learned counsel for the respondent has prayed for time for filing of the county affidavit. What about the interim pay?
My lord, that my interim prayer, my lord, would be, my lord, not to finalize the tender. Though my prayer is for stay, but lordship may, my lord, make it not to finalize the tender, my lord.
We grant that, isn't it? Yes, what about the interim pay? We are going to have hearing about that.
The last directive me to take instructions from the
Yes.
department. Department instruction is I received, and they wanted to file the affidavit to this matter. And the tender is slated to be opened on 25th of this month. It is the 22nd, and 25th the tender will be opened.
25th.
On 25th of
Yes.
this month. So,
Yeah, but you will kindly see in the same order, my lord, same brief, this report also said, while asking them to obtain instruction, it is also observed, interim pair shall be considered on the next date fixed. Because of the date, 25th is the date. So once the tender open and the person is finalized, my lord, they can go ahead with the things, or not to, my lord, award the contract to any selected candidate. That much, my
so
lord.
that can be opened, tender can be opened,
Yes,
but
not
it,
to-
it
not to-
should not, it should not be finalized.
Finalized, my lord. That
But can that happen when you open
Yes.
the tender? Then they have to make some choice.
They'll make comparative statement, they'll select the candidate, but not to issue the LOA. Letter of acceptance or letter of intent, my lord, whatever, my lord, that not to be finalized, that will suffice, my lord.
I think we can do that then, not to finalize the matter.
And in the meantime, on 15th, the matter is coming up, so entire matter can be disposed of.
He is yet to take instructions, okay. So here's his submission is the interim order.
If my department is ready to carry out the joint assessment, joint verifications, even this may not be the proposed, this item number 1. Is because if the department is ready to carry out the joint assessment, this may not have any the effects on the other recommendations. So therefore, just for a moment,
Okay, we'll make it a time being matter, these two.
I'll come with it.
Yes, we'll do some other, okay, we'll take up some other matter. Yes.
Item number 46. I call for license.
Yes.
Yes.
What is 46 about?
In this case, one IA has been filed that was called for. That has not come past after some time, for time.
What is the IA about?
But IA is just for bringing certain facts and some new development that has taken place after filing of the writ petition, so that the relief can be granted appropriately.
We'll list the matter tomorrow. Okay. Because if it's not there and we still have something to look into. Okay, list. We'll make it within this week, okay? Within this week, list, okay, heard, Mr. Your good name, please?
I'm PJ Saikya. I'm assisted by in this case
Mr. PG Saikya, Learned Senate Counsel, assisted by
RS Mishra.
RS Mr. Learned is present along with Mr. SW for respondents for respondent number 1 to 6 and Mr. Okay, Mr. Itapa for respondent number 7. on the submission made by the learned counsels, since the IA in connection with the instead WPC is not on record, matter be listed within this
after
week
tomorrow- day
along
after
with the
tomorrow.
IA.
But can be on day after tomorrow, 24th.
Okay, list the matter on 24th.
It is just bringing on record certain facts.
Along with the IA. Okay, said to be filed by the learned counsel for the petitioners.
24th.
Yes.
Published.
Item number 49 and 50.
May it please, Your Worship.
Yes.
But I'm sorry that I could not take the step on respondent number 2, 3, 6 and 7. Ma'am. And for it may be deferred to 1 week.
Okay, so you take necessary steps, isn't it?
Yeah.
Mr. Tison,
Yes,
said
ma'am.
learned counsel for the applicant is present and submits that he may be granted some more time to take steps upon respondents number 2, 3, 6 and 7.
7.
Accordingly, as prayed for, list this matter after
1 week.
weeks.
1 week.
Okay, after 1 week.
Much obliged.
Item number 51.
Yes, none appeared for the petitioner on call. While Mr. I. Viram, learned additional senior government advocate for the state respondents is present. List after 3 weeks. Yes. That time being matter. Okay, you call me when the parties are present. If it is before lunch, okay? If they are not ready before lunch break, then we'll continue at 2.
Joint verification can be done, my lord, jointly.
Okay. Heard Mr. P.J. Saikya, learned senior counsel, assisted by K. Lalit, learned counsel for the petition, for the petitioner, and Mr. M. Kato, learned DSGI, appearing for respondents number 1 to 4. It is seen that a joint verification report in terms of this court's order dated 04/03/2024 has not been done till date. And the learned DSGI submits that he has received instructions that a joint verification can be done within, when will it be done? Within 3 weeks, 2 weeks?
Within 4 weeks. Madam.
But
No,
won't that?
no specific time has been given, madam. But
Oh, can be done. Can be done. Okay, we'll just make it can be done. In terms of this court's order 04/03/2024. In view of the above, this court find it fit that a joint verification.
Before joint petition. 3 weeks would be sufficient.
Yeah,
perhaps.
in terms of this order dated 03, this court's order dated 04/03/2024 should be done within 3 weeks. Okay, and the report of the joint verification done. Let's just see. Done verifying whether the subcontractor, that is the petitioner/petitioner, has completed.
To
Let's
ascertain
see
to
your
what
prayer.
extent they have done.
Wait, to verify the extent of work, let's just see a prayer in the IA.
Prayer is for payment method,
Okay, it's for payment.
as well as payment method.
shall have a joint verification done to verify the extent of work done by the applicant / petitioner. So as to verify whether the applicant / petitioner is entitled to any payment as claimed by him. The report is to be submitted within 3 weeks.
With a advance copy to us.
Well, since verification is to be done within a period of 3 weeks, then after the compilation, verification has to be done within a period of 3 weeks. Thereafter, compilation, everything, it will take another week. So therefore, within a period of 4 weeks, report of the joint verification or
So verification done within 3 weeks
my lord.
and report submitted on. Okay. We'll list it on after 3 weeks.
Well.
Report submitted and duly submitted. Now report filed and the report should be filed, okay, into the by, okay, let's fix a date. Fix a date.
It can be done by 17th. And matter can be listed on 20th.
By 17
May.
2024.
And matter may be listed by 20th.
Yeah.
With a advance copy to us.
17 and thereafter matters to be listed on 24th, is it? When it should be listed?
20th to 20.
Okay, on 20th, 5/2024, okay. With an advance copy duly served to the
applicant.
Applicant / petitioners. This is in the IA. I'm getting my cough attacks again.
And in item number 1, since it will take time to complete the tender process. So therefore, naturally by that time, the everything will be completed. So therefore,
Well, the tender should not be finalized till the consideration of the report by the school.
So it will not be finalized,
not
it will
finalized.
proceed, isn't it?
Proceed.
See, because you have to protect the interest of both the parties. No, this is, give me item number 1.
Item number 1, WPC 165.
We have not passed an order in that. WPC 165, that was also a pending matter.
165.
Item number 1. Two pending matters we have.
Yes.
IA and the item number 1. So let's completely understand. Heard Mr. So-and-so, assisted by so-and-so, now with Mr. So-and-so. Yes, sir. The learned, Deputy SGI has paid for time for filing of the counter affidavit. In the meantime, Mr. PJ Sakya, Learned Senior Counsel, has prayed that the tender process should not be final. Prayed that the tender process may not be finalized till the disposal of the instant WPC 165. It's in,
Tender process
submitting that,
initiated by NIT dated 13/3/24.
where is it?
13/3/24, NIT dated 13/3/24.
NIT dated 13/3/2024.
Annexure K.
Let that maybe go ahead, but not to finalize.
Not to
it.
finalize, yes.
Go ahead, madam, that might not.
Submitting that, the tender in the NIT has been issued.
Page 79. Dated 79, let me find the NIT. Dated 13th March 24.
Madam, it is selected to be open on, madam, 25th, madam.
Let them go ahead.
It has been issued, wait, what I'm trying to is, which also appears to cover the work already done by them. And finalization of such a tender would adversely affect their rights and interest. Okay, we just make it that short. Accordingly, having heard the submissions made, this court find it fit that to issue an order that the NIT dated so and so should not be finalized till the disposal of the instant. Or let's, okay, till the next, okay, till the disposal of the WPC number 165, 2024.
Well, just one, madam, correction, madam. Tender, in pursuit to say tender may go ahead, but not finalized, madam.
No, finalized, it will go ahead.
Madam.
You don't have to add that.
Madam, that is specific, otherwise department will be again confused.
Okay,
Because may go ahead, madam, and not to finalize.
Is there.
Okay, the tender, the department may go ahead, but not finalize the what?
Tender process.
Tender process. Okay, till the disposal of the writ petition. Yes,
This matter may also be listed on.
When was it
20th.
list on?
20th of May.
Yes, 20th, May 2020.
Yet another matter, item number 46. The counsel for the other side had taken time as the I was not here. Lordship has passed here. Now I is before your lordship. He wants time, madam. So on his ground, madam, matter may be fixed on 24th.
No, what's the I about?
I have for bringing certain facts and documents on record.
Okay,
Subsequent event and the
Mr.
grounds.
So-and-so, learned senior counsel assisted by Mr. So-and-so. This is an application filed for bringing on record certain subsequent events
And the ground
on the
mentioned in
ground
paragraph.
and ground for judicial notice and mold the relief or allow the same by way of amendment of the writ petition in WPC number 23 within brackets AP/2024. The notice is to be issued to the opposite party.
He has already received.
Okay, Mr. Pitapa,
Appearing on behalf of respondent number 7.
appearing on behalf of respondent number 7 and Mr. So-and-so, learned, government advocate, senior government advocate for the state respondents number 1 to 6. Accepts notice on behalf of the respondents. No need to issue any formal notice. Copy of the IA to be duly served upon the respondents, if not already done. Okay.
One week time may be given.
It's only for bringing on record the certain events.
List after
24th, Lordship has already fixed the matter.
list on
24th.
24th, so and so, for filing of written objection, if any.
24th.
Well, objection today, only one day after tomorrow is the 24 losses. It will be too short losses.
But these facts are already there in the various proceedings.
No,
What-
but it's too short, a list after 2 weeks. Okay,
Seven
filing of
weeks.
written objection, if any. They have to get instructions also, but as, though it's very simple for you. Okay. Mm.
But may prefer a date. Madam.
Okay, after 2 weeks on, when do you want it? 2 weeks. After 2 weeks, which date? Give me a date.
8 April.
8th
8 May.
May 2024.
Or it can be on 10th.
They have to
10
file
May,
it,
10
okay,
May.
10th.
10th. Obliged.